Glad to be here and welcome everybody. We're going to talk about, this is part two. We're talking about some unusual assets that sometimes we have to deal with, both on the planning side, but also we'll talk a bit about administration issues. We're going to leave aside digital assets completely from unusual assets today, because that's a whole separate topic. But Ian, here we go. The agenda is we're going to talk about firearms. We're going to talk about cultural property and some special rules around that, ticket licenses, private corporation shares. They may not seem unusual, but we just wanted to raise a few issues because they're so important. And then pets. And so, Ian, anything off the top before we kick off here?
No, just a couple of quick points. We've done a lot of blogging on all of these unusual assets. So if you're looking for some further in-depth discussions, especially on pets and so on, please feel free to search our site. And just, I'm proud to announce I just had my first Tim Biebs and it was delicious.
What flavor was that?
I don't know. It just looked good though.
You don't know.
It's hard to tell. They all taste the same after a while.
After you've had 20 of them, they start to, it's a bit like red wine. Anyway, let's kick it off. Enough with the jocularity. The first issue is that we're going to talk about our firearms. And, you know, it's not every day that we as estate lawyers have to worry about the criminal code, except for you, Ian. I know you deal with that, but for the rest of us, we don't come across the criminal code very often in our practice, but here's one of those where we could. And, you know, we've got different classifications. We've got restricted, unrestricted, prohibited. And the federal government deals with this and requires, our Firearms Act requires that you need to have a license to deal with firearms and to possess firearms. And in fact, it's a criminal code violation and a crime if you possess a prohibited firearm, a restricted firearm, or a non-restricted firearm without a license. So there is this special exemption, thank goodness, that an executor doesn't need a license for the purposes of administering the estate. And there's the authority to possess it for a reasonable amount of time without a license in order to administer. Ian, what do you have? I'm sure you've come across this before.
Absolutely.
Share with us.
So this is real life. I mean, this is where I really do, I sort of, you know, the importance of checking on whether this asset exists when you're doing your intake is so vital. You know, I've got 2 or 3 cases, 2 right now that are hotly contested cases that, you know, one, I've been physically to the premises and someone crowbarred open a solid safe, like firearm safe, and stole the guns while during administration. And another where the client is concerned about even admitting that they're holding the guns just for safety purposes because of the contentiousness within the estate administration. So, I mean, this is real life, and it's not, it typically passes on this problem to someone who really isn't qualified to manage it. A, because they, as you say, the exemption gives you the reasonable time period for executors, but B, more importantly, is that often the executors just hasn't dealt with firearms. And so, you know, this is one of those surprise assets that I really want. I'm very careful with my clients to make sure that we don't have those surprises. Swords are also another cute one, but they aren't quite as difficult. This question of reasonable amount of time comes into play because in the 2 that I'm talking about, these are long administrations. One is tied into contentious litigation. Both of them are tied to contentious litigation. So what the criminal code is going to say reasonable is without a license to manage these versus the what's going to happen in the context of litigation is also a real worry. So you know, I'm quite anxious when I'm taking instructions to make sure that I tick this box.
Yeah, I had, experience with this, and it wasn't, I don't know if, I think it would have been considered firearm, but it was a taser. And I didn't know what to do with it. So I picked it up from the deceased's home and I brought it to the police station. And they said to me, "What are you doing? You're not supposed to be carrying this around." And they said, you just call us and we'll come pick it up. So that was a useful tidbit. You don't walk into a police station with a mask and a firearm. That tends to get the attention. So there are other things. It may be that the testator, the deceased, didn't have registration for that gun, and now you got a problem because you don't get this protection. You now have to register that firearm and deal with all of that. And so there are a whole bunch of things that we have to jump through, and it might be a situation where if the executor, and again, this is a good question, if the executor is prohibited from possessing due to a court order, then you got to get somebody else involved. Obviously, we don't want people running around. Any
Yeah.
other?
No, one of my cases was an estate trustee during litigation who had no idea about it, was an individual, was an accountant, and hadn't seen a shot fired in anger in his life. And so he was a little rattled.
Yeah. And there was some comment in chat about bows and crossbows. So you have to, if it looks like it could be dangerous, that's when you start checking the definition for firearms in the Firearms Act and in the Criminal Code.
Guess you should have checked it for tasers, eh?
Yes, the other one that catches my attention was I had an estate I was the executor of that. It was an ETDL, state trustee during litigation. There's a fight over this. And I go into the basement of the house, and the deceased was, making stuff. He kept the explosives, his gunpowder, in the furnace room. Okay. That was a bad idea. I quickly said, I don't care what we're getting rid of this gunpowder in the furnace room, and it's a gas furnace. Anyway,
Can't make it up.
Yeah, no, that's right. So just a warning. Obviously, if you've got executors, clients who are dealing with firearms, they've got a whole bunch of things to be concerned about, both federally and provincially. So you got to look at all those regulations. The other point, there's the administration where you're handling the firearms, and then there's the whole distribution. And so before you can hand over the guns to the beneficiary, if it's been left to somebody, or where you're making a distribution because you have discretion, that person has to have a license before you can deliver it to them, or else they're subject to the criminal code. And you can imagine how something bad could happen, and this all comes back to you. And so that's why we have to be very, very careful in these circumstances. Any closing remarks on firearms before we move on?
No, let's fire away.
So the next kind of property that we're just going to spend a couple of minutes on really is cultural property. And it's a very broad definition that, it's under the Cultural Property Export and Import Act, and what constitutes cultural property, archaeological, historic, artistic, scientific significance. And so what's interesting is the things that can get caught by that, really. Not only, fossils and Aboriginal artifacts, but military apparel. Medals and other military apparel could be caught in this. And where this becomes relevant, aside from income tax issues, which we're not really going to talk about, is the restriction on exporting these items, and criminal offense if you export it. without a permit. And so if the beneficiary of, you could be going around through the personal effects and distributing them to US, beneficiaries, for example, and all of a sudden, one of those items is a, Canadian Cultural Property Export Control List item. And so just something to have another concern about when you're administering an estate with unusual, and boy, do we see unusual things that people have. Ian?
Yeah, well, this is absolutely another one of those things, though, that what I've found is, and we all probably, well, not all, some of us may have seen the last couple of weeks, where the Vatican put on display an ancient kayak that they have in their museum that they'd pulled out of storage, and they put it on display proudly. And then, of course, the Indigenous community from Canada that it was from, or said, well, we want it back right now. Well, that happens a lot with the cultural property and administration in the same scenario, and that is that it's a surprise that it is cultural, and it's a surprise that it has that status. And if you ask the client on rare occasion when you're doing the intake, they probably don't even know just how rare, or if it is a cultural property, and what kind of headaches it's going to create for you. So it's even one of those harder issues, because you can't anticipate it necessarily, because the clients may not have identified it as being something that's going to require this extra step. So again, I just come back to the same thing as, err on the side of caution. If it looks like something that is unique, and it's really the first time it becomes shown to the public is when the deceased dies, pay careful attention to these steps.
Yeah. So, the other issue becomes whether the deceased owned these items legally, right? I mean, in where they received them improperly. And so, you get into a downward spiral, in a sense, where there are issues that, the artifacts weren't properly possessed by the deceased. And now what do you do with them? Have you come across that ever?
Well, I think that's the kind of scenario that came out of the Vatican situation, but it is, I've had two situations like that. One was an ancient burial piece from made of soapstone, and it was an Indigenous piece that the deceased had not been entirely honest as to how she got it many years ago on a trip up in Northern Ontario. And we had to deal with it, and we had to reach out to the community, which we identified where she got it from, because it was obvious. It was a very big piece. And the other one I just had, is that there are certain artifacts that may be in existence from the war that clients have, squirreled away, and you're all of a sudden you're faced with that have not just cultural property issues, but historic legacy behind them that needs to be addressed. And then in those situations, it's often that you might find something that from the Germany, from the World War I or World War II from Germany, that might bring with it cultural significance, but also ethical and primarily distribution problems.
And so, yeah, there's a board that deals with these issues if there is a question as to whether something meets the definition or not. There's a lot of information on the web and how to deal with qualifying whether something is cultural or not. Want to turn to ticket licenses. We began in part one with this discussion that, we look at sort of whether we can dispose of certain assets in our wills, and and the third parties that might be responsible for that kind of issue. So ticket licenses. So I'm just checking that there was one of our participants dealt with an estate where the deceased was using a World War I grenade, German hand grenade, as a door stopper, and it turns out it was still live. Nobody would believe that. You put this on TV, they're like, yeah, this didn't happen. So that's why we're in this business. It's kind of cool. So just focusing back on ticket licenses. So season tickets, like the Leafs or, whatever, for example, are not necessarily transferable. So it depends on the contract and the license agreement under which you have the ability to buy these shares. So, for example, I think I don't know if I mentioned this, but I have Maple Leaf tickets in my name since 1946, and they're not in my name; they're in my grandfather's name. But I've never actually had them transferred. He would be 121, so it's unlikely if they were checking in if Maple Leaf Sport and Entertainment is watching, they better not call me. But you can only gift them down to blood relatives and not spouses, interestingly. So each rule, and they change too. The other thing is these rules change. So you have to go and double check that you can do what you want to do with that. So, the other thing is that, when you're making a bequest of a seat license, that, or the right to buy these tickets, that they can afford to actually buy the tickets as well, or else it's going to be a burden to them, and they're probably going to disclaim that. So Ian, I'm sure you have some ticket license.
I've litigated over Leaf tickets, so I God bless the Leafs, but I'm not a high flyer like you, but I have Marlies tickets, and so I put them in a corporation to see if that's going to work over transferring it on, because my kids don't have the high expectations that yours do about seeing real hockey. I just go to the lower level.
I just on that note, I was the last time the Leafs won the Stanley Cup. Do you know the year?
1967.
Right. Do you know the date?
No.
May the 3rd. I was born on May the 13th, 1967, making me one of the oldest people who's never seen the Maple Leafs win the Stanley Cup. So it's probably my fault. So
isn't that great? Well, you're the Boston curse.
Could well be. So let's talk about, we've got a couple of topics left, the private corporation shares and pets. And so I did want to leave a little more time for especially private corporation shares. And as we said in the part one, sometimes the ability to dispose of assets are subject to agreements that the deceased entered into during their lifetime. And one of the classic ones is a shareholders agreement, and how that impacts, because often there are transfer restrictions in a shareholders agreement as to who you can transfer shares to. And that's exactly the case. And Ian, I don't know if you want to talk about this case a little bit, but the Fry estate case from 2008 from the Court of Appeal really was your classic problem. And it was very interestingly solved, in a sense, by the Court of Appeal. And I'll just maybe go through the facts, and maybe then you can sort of, we'll talk about the ratio. But the shareholder agreement in that case prevented the transfer of shares without the consent of the board. That didn't stop the testator from bequeathing his shares to a person without the board's consent. So the board said, well, we're not consenting to the transfer. And the beneficiary said, well, the testator wanted me to get it. So what do you do? And so, Ian, do you have any comments about that at this stage?
Well, no, go ahead. You finish the thought, because I like the way you're describing it.
So what did the court do here? They were caught between a rock and a hard place. The board saying no, but the testator saying, look, I want, otherwise these shares are not worth anything, and they're not going to the right person. So what the court did was yes, there is a breach here of the shareholders agreement. So the testator's shares still remained in the executor's name. They couldn't go out to the named beneficiary. So yes, legal title could not be transferred. But what the court said was that the executors were in effect holding those shares as bear trustee for the beneficiaries. I don't know who came up with that idea, but it was certainly interesting. And so that's sort of what happened in that case, and that's sort of where we are, because it was the Court of Appeal. What do you do in these situations, Ian?
Yeah, well, look, I mean, the Fry decision is out there, and there's lots of controversy hovering around it because this was a manufactured solution to a practical problem. But you're right, it's still good law, and it's an important in terms of that, because people come into these situations expecting that shareholders agreements are going to prevail.
Right.
And as it didn't in this case. So well, I mean, I guess why don't we can talk about you've got the Treasury decision as well, but we can talk about what people are doing. But I mean, the will itself is a cornerstone in directing where the shares are going to go. And that's what essentially Fry said.
Yeah. And they left it basically, you guys figure it out. This is what we're doing. We're putting you both in a bind. And this was that I think that's really, I don't think the court knew what to do, quite frankly. And they figured, I'm going to tie you guys up together and you're going to have to figure it out. But it's not easy to advise our clients who are subject to these shareholders agreements about transfer. I mean, I think we do have to indicate to them, obviously when we're acting for a client who owns shares in a company and they're not the sole shareholder, that that looking at the shareholders agreement is really crucial. Not unlike getting a copy of the separation agreement. There may be limits that you can't achieve, and by putting it in the will and having the client believe that they're trying to achieve something, you can see how the lawyer could be criticized for not reviewing the shareholders agreement. And I don't know in this case if they did, but saying to the testator, look, this may not work, and this may cause a whole bunch of problems. And so that's the problem we have is that we don't have a clear answer. We can kind of do it. And and that's one of the issues, right?
Yeah, and I think one of the problems I have is that I don't have the corporate expertise to be reading these shareholders agreements with a deep understanding of its impact, and sometimes they're so long it's even harder to read than a will. So it really puts us in a bind. And so my practice tends to be saying, look, the shareholders agreement from a practical standpoint is likely to prevail, notwithstanding Fry, but we don't know if this is going to work. And as long as I've reported it out on that basis, or I will lots of times in large estates say to the client, look, let's get some advice on this, because I'm not going to give you an opinion on the efficacy of the impact of the shareholders agreement. I'm just an estate lawyer. What do I know? So it's just I think it's a practice issue and a practice management issue too.
Yeah. I'm just going to minimize something because I wanted to show something when we talk about this next section, which is some help that the Court of Appeal. If the Court of Appeal didn't help us with Fry, they did help us as lawyers with Treasury. And Treasury was the not so unusual circumstance where the testator tried to give away an asset that he didn't own, but in fact was owned by a corporation that he controlled. And so, this was the Earl and Wilhelm problem. That was an old case where the court, in that case, it was from out west, Saskatchewan, said, no, you as a testator can't give away assets that were owned by a corporation, even though you own the corporation. But Treasury goes contrary to that, thankfully, in a sense, for lawyers, where they got sued in Earl and Wilhelm and liable for that. So what Treasury says is, you're going to get around that. We're going to allow for that, and we're going to basically look at the will and say, does the will give the power to the executors to affect this gift? And if it does, we're going to allow them to do it. So that was a helpful case. Ian, do you want to just speak about that? I'm just going to call up how eState deals with this issue.
Yeah, well, no, and Trezzy certainly took some of the wind out of the sail of the uncertainty of Fry. But what it still comes back to though is when you have these what is comprehensive shareholder agreement terms, it always worries me that even Trezzy isn't going to solve all the problems that Fry created. But go ahead.
Yeah, so what we typically include in what eState would include is a clause where it says, look, to the extent that my will directs my trustees to make certain gifts or transfers or et cetera, even forgive loans in respect of specific property that's owned or controlled by a private corporation that I control, I'm directing the trustees to take the necessary steps to elect directors or whatever else needs to be done to affect those gifts. And that is, if you don't want to rely just on Trezzy, that might, again, it looked at what the terms of the will had. So this is a specific and direct term that allows it. And so I think that's helpful in case you miss something, or not even if we miss something. What happens if the client then transfers that property, rolls that property into the corporation that they were trying to specifically devise or bequeath after the fact? So that's not just a liability problem. So just want to address that. And the last thing, and we have 3 minutes, which is perfect, is to talk about pets. And of course, pets are not people. They can't be beneficiaries. They can't inherit property. So you can't leave cash to a pet. But what you can do for providing for pets, and I'm just going to talk about the one most common plan, which is to create a payment to a person to look after the pet. And in this case, this is sort of my standard wording that says, look, I'm going to allow the trustees, I'm going to pick the pet recipient, or let the trustees pick the pet recipient if that person isn't willing. And then I'm going to figure out an amount. And this number 2 is sort of how I do it. I take the pet and the average age for a pet, and you can use whatever number you want here. And I picked 15 for different pets. It can be 18 or 20 or whatever. And then I say, look, subtract the age from that number and pay them at the time of my death, and pay my pet guardian or my pet recipient that amount, annual amount, based on a life expectancy, of a remaining life expectancy. And so that's just how I tend to do it. And then I say to them, look, you have to give a written undertaking when you get that money that you're going to look after the pet with that money. But my trustee is not responsible for making sure that that's done. It's more just a moral obligation. So that's sort of the way that I typically deal with provisions for pets. Ian, any closing remarks?
Well, I think you're the leading expert on this, because you've been an executor of a very big estate that had a big bequest like this. And I know it's a moral and a professional headache at some level for the executor, for sure. But I just harken back to 2007 when the Globe and Mail called me up after Leona Helmsley died, and she gave $12 million to her dog. And I was as shocked as anyone, and all I could say was, it's a lot of dough for a dog. And that was the quote I got out of the Globe and Mail. So you got to be careful when you talk to the press.
I'll remember that. That is a lot of dough for the dog. There was a question about whether eState populates this. Not yet, but I'm glad to tell you that we're very close to releasing some additional features that are going to help us out. And so this hopefully will be in there. If not, it'll be coming down the pike very soon. So yeah, that's where we're at. So thanks, everybody. Thanks for your attention. Thanks, Ian, for joining us. And hope everybody has a good afternoon and week. And we hope to see you again. Thanks very much.
Thanks, Jordy.